Good morning, everyone, and welcome to our wonderful program that we have this morning. We have Stacey Salgado from the New York State Department of Labor here to give us this fantastic presentation on the employment rights and benefits that are especially important to women workers in New York State. Thank you for joining us. If you have any questions or comments, please use the chat feature or the Q&A feature on Zoom, and we'll be happy to respond to those questions. So with that, take it away, Stacey. Thank you so much for coming down.
Good morning. Thank you, Sal. Thank you for having me. Appreciate it. This morning, we're going to talk about FAIR, otherwise known as Fostering Access, Rights, and Equity under the Federal FAIR Grant here in New York State. To provide a little bit of background on that, we at the New York State Department of Labor received a grant from the Federal Department of Labor with the purpose of doing outreach specifically to women workers to promote awareness and spread that information about employment rights and benefits that are important to women and to know where to turn if faced with certain issues. That being said, this information is really great for anybody to know, but like I said, some of the topics are going to be a bit more nuanced towards women workers. So we do have a website noted on the slide here that's dedicated to the FAIR grant and all the topics that I go over and a bit more. It's really there as a resource for you, so definitely feel free to visit that site, do a little bit of exploring to look up information, learn new things. There's also Test Your Knowledge on Workplace Rights quiz that's available that will also teach you if you get any answers wrong. There's fact sheets on all the topics, any resources that have to do with it. And if we have translated anything into other languages besides English, those fact sheets will also be posted on this website. So as I mentioned, the goal here is to share information on employment rights and benefits with the hope that you'll learn something new about the topics that are of special interest to you or importance to you, and to know what to do if you are faced with a problem in the workplace. So let's take a quick look at our agenda. First, we're going to get into some wage and overtime topics, misclassification or the difference between employees and independent contractors, leaves and benefits, additional rights and protections, and how to actually go and file a complaint with the New York State Department of Labor. So first and foremost, let's get right into wages and overtime. So one of the reasons why this outreach to women in New York State is so important is because we do still have work to do in closing the gender wage gap. The picture that you see here on this screen, the woman in the middle, is Roberta Reardon. She's the commissioner of the New York State Department of Labor. And this is a picture of her back in January 2023 at one of two public hearings that we held here in New York to gather testimony on the current state of the gender wage gap. And so she says, in New York State, for every dollar a man earns on average, a woman earns just 88 cents. That gap is even wider for women of color to white men. For Black women, that gap is 68 cents, and for Latina women, it's 63 cents. It is not right, and I think we can all agree that we need wage parity today. So like I said, that gives us a good stepping stone as to why it's important to educate and help to close this gender wage gap. And the next few slides that we'll go over here are going to give some information specifically on some laws that we have here in New York State, some newer that are working to close this gender wage gap to make a more equitable pay for everybody and a more even playing field. So as I mentioned, some of the laws that we have in place here in New York State to promote, pay equity. First and foremost, we have the salary history ban law, and that went into effect back in January of 2020. And as I've been giving these outreach presentations, I have definitely found that this is a law that many people, for whatever reason, were not aware of. So this is a really good one to pay attention to if you've never heard of it. So basically what it says is that an employer can ask an applicant for their expectations for a salary that they would like to make when applying for a job at that company, but the employer can no longer ask what the applicant earned at their past jobs. So that's a huge change. Like I know back when I was applying for jobs, it was always the norm that you have an application that you fill out. It's going to ask you, what did you make it? Every single job that you're putting down in that history. And so that is no longer here in New York State. So this rule, it applies both orally and in writing to the employer asking the applicant directly or indirectly through another party. And it also prohibits the employer from relying on an applicant's salary history information as a factor in determining whether or not to interview that person, offer them employment, or in determining what salary to offer them altogether. I do want to note this does not apply to independent contractors or freelance workers. Um, but like I said, this is new in the past few years here in New York State. So really, the idea here is that salaries are not being perpetuated. So, for example, if you have a woman in a certain job and um, she's going to a new employer, that new employer is basing her pay off of what she was paid on her last job, and it's kind of like you're treading water, like you're never really getting ahead. So it's getting rid of that idea. So I do want to note on that topic that, of course, if somebody wants to negotiate their salary, it's fine if they want to choose to disclose what they were paid at a past employer. That would be up to the applicant. So this law, it does not prevent workers from voluntarily disclosing their past salary information, like I said, for purposes of negotiating a salary. And then an employer can go ahead and confirm that past salary for the purposes of negotiation once they've actually made an offer of employment, including compensation. Now, we have this is really a brand new law in New York State. It just went into effect last month on September 17th. It's the pay transparency law. So what this says is that employers here in New York State that have 4 or more employees have to include in their job postings a salary or a range that they are going to be paying for that job. So this applies to all jobs that are going to be performed at least in part in the state of New York, as well as promotions, transfer opportunities, even a remote job that's going to report to a supervisor in New York. Let's say there's a lot of nuanced details to this. But the idea is that the posting for the job, it has to advertise the salary or the salary range that the employer believes in good faith to be accurate at the time of posting. And it should give the prospective applicant a legitimate idea of what to expect as far as the pay goes. So I have some examples here of what would be acceptable versus unacceptable in a job posting. So acceptable examples would be a flat hourly rate, let's say $19.50 an hour, a range of salary, 40,000 to 50,000 a year, or it could be something like $18 an hour plus tips. Something that would be unacceptable would be an open-ended salary range, like $17 an hour and up, because we really don't know what is the maximum when it's written like that. Or on the other hand, if you say a maximum of $55,000 a year, we don't know what the minimum is with that example. So the purpose behind this law is, a couple different things, but obviously first to empower workers with this really important information right up front so they can decide whether or not they even want to apply for this job, um, and to address systemic pay inequities and discriminatory wage setting and hiring practices. Um, if you want to find out more about this law, there is a lot of information available, both on the FAIR webpage as well as the Department of Labor webpage in general. There's Q&A, there's fact sheets, for both workers and for employers, of course, to know, how to be in compliance with this law, what their job posting needs, and how they should write it. So a little did you know, employers can impose workday and workplace limits surrounding employee discussion of salaries with other employees, but an employer cannot flat out prohibit employees from inquiring, discussing, or disclosing salary with one another per Section 194 of our New York State labor law. And under that same section of labor law, we have the equal pay provision, equal pay for equal work. And so this law prohibits unequal pay based on a protected class for all substantially similar work. So breaking that down a little bit, first of all, protected classes can be a number of different things that you see on the slide here. It could be a person's age or their race, creed, color, national origin, sexual orientation, gender identity or expression, military status, sex, disability, predisposing genetic characteristics, familial status, marital status, or domestic violence victim status. So just an easy example for the purposes of this presentation, it would be illegal for an employer to pay a woman less than a man for doing the same job solely on the basis of their sex or gender. So a difference in pay, it has to be based on something legitimate, like that person's seniority, merit, quantity or quality of production, or some other sort of bona fide factor, like other than that person's sex, like their education, training, or experience. And we do take complaints at the Department of Labor. If you suspect you're being paid differently than your coworker that does the same job based on any of these protected classes, this is something that can be reported to us at the Department of Labor. And at the end of this presentation, I will tell you exactly how to do that and give you a bunch of contact information. So going into, let's say you get hired at a new job. This is an example of a pay notice template that the Department of Labor provides. Employers are not required to use our templates, but they're welcome to. They can use something of their own design as long as it has the required information on it. But just to give you an example, when you do get hired at a new job, you should receive some sort of pay notice or work agreement that puts some details in writing between the employee and the employer, as far as what has been agreed upon for the pay, anything that's going to be coming out of the pay, and what is the regular payday? How often is that person going to be paid? Are they eligible for overtime? And if so, what's the overtime rate? Now, employees should always receive a copy of this to sign and, keep a copy just in case they ever need to refer back to it. If the Department of Labor provides these templates in other languages that happen to be, that worker's primary language, then a pay notice should be provided in that language. If we don't have the pay notice translated into the worker's primary language, then it's okay just to provide it in English. Both parties will sign and both should keep copies, as I said. So next, I'm going to give you a bit of an overview about our minimum wage. Can be a little bit confusing because there's a lot of different rates for different areas of the state and even different jobs. So we have a chart here that's breaking it down as far as what the minimum wage is currently at right now. For work performed in New York City, Long Island, and Westchester County, it's going to be $15 an hour. And then for anywhere else in New York State, it's $14.20 an hour. For fast food work anywhere in our state, it's already at 15 an hour minimum. And then new last year in 2022, they did implement a specific minimum wage for home care aides. Home care aides being defined as individuals who provide assistance with activities of daily living in a patient's home. And so their minimum wage is to always be $2 an hour higher than the basic minimum wage. So that's why you see that $17 an hour rate for New York City, Long Island, and Westchester, and then $16.20 an hour for the rest of the state. Now, the link that you see on the screen here, that does bring you to a minimum wage lookup tool that we provide. Just because there are so many different rates, it usually changes every year. There's the different locations, different types of jobs. So you can plug in the details that you're looking for, and it will let you know what the minimum wage is for that scenario or what it was in the past. You can look that up too. Now, with the new year coming up, just in a couple short months here, really, we are going to see another increase. It's going up to $15 an hour, where it was $14.20, and then $16 an hour for New York City, Long Island, and Westchester County. So for workers who receive tips as part of their wages, the minimum wage can look a little bit different. New York state law does allow employers to satisfy the minimum wage by combining a wage paid by the employer with tips that the employee receives from customers. This is only allowed in the hospitality industry, where those employers can take tip credits from minimum wage. Employers outside of the hospitality industry are not allowed to keep any portion of a tip that an employee receives. Again, we have a chart here for New York City, Long Island, and Westchester, and versus the remainder of the state, and the base wages plus the tip credits that are allowed. So you'll notice if you were to add those numbers together, you're going to arrive at either the $15 an hour or the $14.20 minimum wage. So the idea there, just a simple example, let's say we have a waitress working in Long Island. Her employer could pay her the $10 an hour and made up with $5 an hour, at least from tips from her customers, to meet that $15 an hour minimum wage. As far as overtime goes, most workers have to receive overtime after working 40 hours in a work week, and that overtime pay would be time and a half the regular pay rate. So for example, let's say it was $15 an hour, the overtime rate would be $22.50 an hour. Of course, there are certain administrative, executive, professional employees who earn over a certain amount that are going to be exempt from overtime. If you have a question about your specific situation, if you should be receiving overtime or not, you can always contact the Department of Labor for help in determining that. And then as far as agricultural workers go, their overtime looks a little bit different. They have some new laws in place because they were previously excluded from overtime provisions, but currently they will earn overtime after working 60 hours in a work week and for any hours worked on their designated day of rest. And there is basically a phase in place to bring that $60 hour per week threshold down to 40 an hour over the next 10 years. So it is okay for you to be paid in cash or by check. by an employer. Either way, you should always be given a pay stub, wage statement, some sort of record that you can keep, whether electronic or paper, that is just showing you those important details as far as who was the employer, who was the employee, what were the hours worked in the pay period, and then the wages before any taxes or deductions were taken out, what came out of that pay, and what the result was there. So we always tell people, workers, that it's a good idea to keep track of the days and hours that you work. Keep a record on your end so that you can always compare it with what you're being paid for to make sure you're being paid for all the hours you worked at the agreed upon pay rate. And then, of course, pay stubs are going to be important. If you have them available and need help from the Department of Labor, those would be important, very useful records for us to be able to look at. As far as deductions from your pay go, there are certain things that are legal in New York State and other things that are illegal to deduct from a worker's pay. So on the top here, we have a list of things that are acceptable, and we're all very familiar with these being deducted, like Social Security, Medicare, taxes, union fees if applicable, and then other deductions are fine if they are for the benefit of the employee and the employee has authorized them in writing. So those would be things like a health insurance plan or retirement plan, something of that nature. Items that cannot be deducted in New York State include breakage. So if you break work equipment, spoilage, spoiled food or products, the cost of your uniform and maintaining the uniform, employer business costs, or cash shortages from your cash register, let's say. It is illegal to deduct these items from a worker's pay in New York State, whether that be deducting directly from a paycheck or trying to have a worker pay the employer back on the side. That is also illegal. And again, this is something that you could always report to us at the Department of Labor for assistance. So segueing into our next topic here, which is worker misclassification and the difference between employees and independent contractors. Okay. So misclassification is something that happens when an employer classifies a worker as an independent contractor when they should really be classified as an employee. So this is a tactic that some employers might use in order to avoid complying with certain things like unemployment, workers' comp, Social Security, taxes, disability, minimum wage, and overtime laws that protect workers. So to tell the difference and to see how somebody should be classified, you have to examine the relationship between the employer and the employee. So an employer-employee relationship, for example, this looks like when an employer tells the employee when, where, and how to do the job and directly supervises the job, sets the work hours and rates of pay, requires prior permission for absences, provides facilities, equipment, tools, or supplies in order to do the job, and provides compensation in the form of a salary or hourly pay rate. On the other hand, an independent contractor is someone who's in business for themselves and makes their services available to the public. They perform their services free from supervision, direction, and control. If an individual or a business needs help in determining a worker's employee or independent contractor status, there is a federal form. It's called the SS-8, and that could be filled out and submitted to the IRS, who will make the determination on the worker's classification. So misclassification is considered a form of fraud, and that can be reported to the Department of Labor, either online at the link that you see on the slide, or there is a 24-hour hotline that anyone can call and leave a message. It's 1-866-435-1499. And individuals can remain anonymous if they choose. However, it's always a good idea to provide as much detail as possible so that the Department of Labor can thoroughly investigate the tip. The Department of Labor will keep all information confidential to the greatest extent possible. The next section we'll get into here has to do with some different types of leave and benefits. So first, we'll talk about New York State Paid Family Leave. This is a program that provides eligible employees with job-protected paid time off to either bond with a newly born, adopted, or fostered child, assist loved ones when a spouse, domestic partner, child, or parent is deployed abroad on active military service, or to care for a family member with a serious health condition. For the purposes of this leave, the family member can include a spouse, domestic partner, child, stepchild, parent, step-parent, parent-in-law, grandparent, grandchild, or sibling. And sibling was just added to that list this year in 2023. The paid family leave also provides continued health insurance and protection from discrimination and retaliation. As far as eligibility goes, most employees who work in New York State for private sector employers are eligible to take paid family leave. So full-time employees who regularly work 20 or more hours a week, they become eligible after working 26 consecutive weeks of employment, which works out to be about 6 months. Part-time employees who regularly work less than 20 hours a week become eligible after working 175 days, which do not need to be consecutive. So employees are eligible for this regardless of citizenship and/or immigration status, as well as gender, gender identity, or sexual orientation. So the paid family leave program, it actually gets funded through employees themselves via a small weekly payroll deduction. That weekly payroll deduction, it works out to be about 1/2 of a cent for every dollar that person makes. The total yearly contribution, it does get capped. So for 2023, $399.43 is the highest amount that any one employee would contribute to paid family leave during the course of the year. And then eligible employees can take up to 12 weeks of leave, and that would be paid at 67% of their average weekly wage. The maximum benefit for 2023 is $1,131.08 a week. So that's the highest amount that any individual can receive on a weekly basis while on paid family leave. And we do get asked sometimes if people are able to opt out of contributing. And the answer is no, that the contributions are not optional, but there are some part-time or seasonal employees who might qualify for a waiver simply because they might not ever work enough hours to ever become eligible to utilize the benefit themselves. So if you ever want to apply for paid family leave, excuse me, the first step would be to notify the employer. And that would happen really just as soon as possible. Ideally, you would have a 30-day notice, but obviously it's understood that you're not always going to have 30 days notice, just as soon as possible. And then you would obtain and submit the required forms and supporting documentation to the employer's insurance carrier. The insurance carrier then has to either pay or deny the request within 18 days of receiving everything, so it's a fairly quick turnaround time. The web page link that you see on the slide here, it does have the required forms. It has a lot of information there as far as like fact sheets and FAQs. There is also a helpline number, 1-844-337-6303, that you can call to ask questions either on the employer or the employee side for paid family leave. And I've called it a few times myself, and it's pretty easy to get through to a human being and ask your questions. So definitely feel free to make use of that if should you ever need to. So pivoting a little bit, but still important, the New York State COVID-19 paid leave. This is actually under our paid family leave umbrella here in New York State. And this is something that is still in effect here in New York State. Some people um, haven't been aware that these benefits are still available, they still exist, and they're still legally required here in New York. So um, if an employee is under a mandatory or a precautionary order of quarantine, um, the employer may be required to provide COVID paid leave. We have a chart here breaking down the requirements based on the size of the business. So if a business has between 1 and 10 employees and their annual income is less than $1 million, they would not be required to provide the COVID paid leave. The employees would instead use a combination of New York State paid family leave and disability benefits to cover any leaves due to COVID. And then businesses between 1 and 10 employees and an annual income of more than $1 million, as well as businesses with between 11 and 99 employees, are required to provide at least 5 COVID paid sick days. And then businesses with 100 or more employees are required to provide at least 14 COVID paid sick days. And this applies. The law states that no employee can utilize this leave more than 3 times. So that would be for 3 separate instances of COVID or mandatory precautionary order of quarantine. And you'll notice here the phone number for help is the same as the paid family leave helpline, as I said, because the COVID paid leave is under the New York State paid family leave umbrella. They also have a section dedicated to this topic on that same website link. So while an employee is out on COVID leave, there are certain protections that they have, including job protection during the leave. An employer cannot fire or act against an employee because they took this leave. Employees are entitled to be restored to the position that they held prior to taking the leave. And any COVID-19 quarantine leave should not be counted as an absence that may lead to or result in discipline, discharge, demotion, suspension, or any other adverse action. Affected employees can file a complaint with the New York State Department of Labor. At the website link you see here, it now falls under the New York State HERO Act, which was born from the pandemic. It not only encompasses the COVID-19 regulations and taking those complaints, but also the idea of emergency preparedness. And, so if something like this were to happen again, we would be much better prepared at our work sites and, the different precautions that we take and things like that. So if you or someone has doubts about, this COVID leave, you can check out that website or give us a call. So we also have the New York State paid sick leave and safe leave. This came about in 2020, and it is, although it kind of sounds the same as what we've just been talking about with the paid family leave, the COVID leave, this is actually something that is completely separate from and additional to that. So keep that in mind. So private sector workers in New York State are covered under the state's sick and safe leave law. The amount of sick leave that's required depends on the size of the employer. Again, we have a chart breaking down the requirements. Like I said, this started back in 2020. The idea here was that if employers were not providing any sort of sick leave to their employees, it was now putting into effect some certain requirements. So if you were working somewhere and already were getting sick leave that met or exceeded this law's requirements, you probably didn't notice anything change. Um, but for businesses that weren't offering that benefit or maybe not meeting the minimum standards, it required them at that time to start doing this. So the accruals began September 2020, and then workers could begin utilizing their sick leave accruals January 2021. And so what it says is that if a business has between 0 and 4 employees and their net income was 1 million or less in the previous tax year, they have to provide up to 40 hours of unpaid sick leave per calendar year to their workers. So what that means is that they had to provide the time off, not necessarily the pay. Um, on the other hand, businesses with between 0 and 4 employees and a net income of greater than 1 million in the previous tax year, as well as employers with between 5 and 99 employees, they're required to provide up to 40 hours of paid sick leave per calendar year to their workers. And businesses with 100 plus employees have to provide up to 56 hours of paid sick leave to their workers per calendar year. Again, we have a website link that you're welcome to visit if you have questions that you want to look up about paid sick leave. The accruals work as follows. So at a minimum, employees have to accrue 1 hour of sick leave for every 30 hours they work. Or employers can choose to provide the full amount of sick leave that's required by this law at the beginning of each calendar year. So, as a bank, for example, that the workers would draw from as the year goes on. If you choose to do it that way, the employer cannot turn around later and revoke or reduce the leave that was given at the beginning of the year. If an employee wants to use these accruals, um, they just have to submit a verbal or a written request to the employer. There's no time period designated under the law. An employer can only require documentation if the leave lasts for more than 3 days in a row that that worker was previously scheduled to work. And the documentation, it only needs to support the need for the leave, but of course shouldn't um, provide any confidential information or the exact reason for the leave. So these sick leave accruals can also be utilized for purposes of safe leave. So if an employee is impacted, for example, by something like domestic violence, a family offense, a sexual offense, stalking, or human trafficking, they could utilize these accruals for different types of purposes like obtaining services from a shelter or a rape crisis center, safety planning, moving, meeting with an attorney, filing a report with law enforcement, enrolling children in a new school. Um, so, all of the rules are the same as far as use and documentation, whether the employee is utilizing for sick leave or for safe leave. So we will get into now, this next section is kind of like just a mix here of different topics, additional rights and protections, other things that are good to know. So our labor law in New York State, it says that all workers are protected by labor law regardless of immigration status. And as far as language access goes, we also have certain rules in place. So if a person's native language is not English and they prefer to communicate in their native language, Staff at the New York State Department of Labor has to use an interpreter to assist that person. And that is true for any state agency that provides direct public services. So at the Department of Labor, we have written vital documents in the top 16 languages that are spoken by limited English proficient individuals in the state, which currently are Spanish, Chinese, Korean, Italian, Russian, Polish, Bengali, Arabic, Haitian Creole, Urdu, French, Yiddish, Japanese, Hindi, Albanian, and Greek. And then materials in other languages may also be available. So we have access to telephonic and or remote video language interpretation services in more than 200 different languages, of course, including sign language. And these are just a couple pictures of posters that you should see displayed in state offices that serve the public. So a poster letting people know that sign language interpretation is available, as well as a language identification tool, which helps to identify language that might be needed for interpretation. So it says in more than 30 languages, point to your language, an interpreter will be called. The interpreter is provided at no cost to you. So like I said, just kind of a mixture of topics here. So pivoting to something completely different, but important nonetheless. So we, for several years in New York State, have had legislation surrounding the rights of nursing mothers to express breast milk in the workplace. And earlier this year, in June of 2023, we did have some expansions to these laws. So, nursing mothers in New York State workplaces, so that all New York State employers are required to provide convenient private pumping spaces in the workplace that include a table and seating, light, electricity, and nearby access to clean running water. On that note, per New York State and federal law, the space that's provided for this cannot be a bathroom. Employers must also implement a written policy regarding employee rights when breastfeeding in the workplace. So under New York State law, nursing mothers are guaranteed break time to express breast milk at work for up to 3 years following childbirth. Employees who make use of this benefit have the right to take either reasonable unpaid break time or to use their paid break times or meal times during the workday to express breast milk at work. They're also allowed to make up that unpaid break time either before or after their shift if they choose to do so, as long as it falls within the employer's normal work hours. And the employer cannot discriminate against an employee based on her decision to express breast milk at work. We do have a web page link that's dedicated to this topic with, Q&A, fact sheets, all of that good stuff that breaks it down further. And the policy on the breastfeeding, the new laws, is available there as well. Now, as far as sexual harassment in the workplace goes, all employers in New York State, regardless of the number of employees that they have, are responsible for providing a workplace that is free from sexual harassment. Employers have to have a sexual harassment prevention policy in place and provide annual training to their workers, as well as a copy of their written sexual harassment prevention policy. If a worker ever needs to report sexual harassment in the workplace, they have the option, of course, to report the conduct to the employer. Sometimes that doesn't turn out to be the best option for whatever reason. Maybe the employer is the harasser, or maybe that person just doesn't trust how the employer will react to them. They also have the option to contact the New York State Division of Human Rights, who can assist with taking and investigating complaints. Previously, harassment had to be severe or pervasive before it was considered against the law. As of October 2019, this was changed by an amendment to the human rights law so that harassment is considered unlawful when it's anything other than petty slights or trivial inconveniences. Beginning in August 2020, the time period for filing a sexual harassment complaint with the Division of Human Rights was extended from 1 year to 3 years. It is unlawful for an employer to retaliate against an employee for reporting sexual harassment. So on this slide, we have some contact information for the New York State Division of Human Rights. They do have offices located all throughout the state. You can visit in person, you can call, you can fill out a complaint form online on their website. There's also a sexual harassment hotline, which I believe just became available this year. It is 1-800-HARASS-3, the phone number. And this is a hotline that is staffed by volunteer attorneys. So if an individual calls, they will speak with an attorney that can talk about situation, get advice, and also go ahead and put in a complaint right then and there if they choose to. So finally, we have talked about a ton of different topics today. So just to recap some rights and talk about how to go ahead and contact us at the Department of Labor should you ever need to. All workers here in New York State, regardless of citizenship or immigration status, have the right to find out what the labor law requires, ask an employer to fix a possible violation, give information to the Department of Labor and/or file a complaint, pursue all wages owed to you either through the Department of Labor or through a private legal action, answer truthfully when interviewed by a Department of Labor investigator, testify in an official proceeding under the labor law, and not to be dismissed or discriminated against because you exercised your rights under the labor law. So as far as how to go ahead and file a complaint with the Department of Labor, we have a division within the Department of Labor that's called Labor Standards. They are the law enforcement division of the Department of Labor, and they help to resolve violations of New York State labor law. They investigate, they help to bring employers into compliance, and take complaints and all of those things. So we do have a general complaint form. It's called the LS-223. And I give you the name of that form just in case you wanted to Google it or pull it up on our website. But other than that, you really don't need to remember the name of that form for any other reason. But it's kind of like a boilerplate form. It can take complaints on a number of different topics, whether it be unpaid wages or a minimum wage violation, illegal deductions, if you're not getting your lunch break or something of that nature. We also have shorter, more specific forms for a couple of the topics we talked about earlier in the presentation, like the salary history ban law and the equal pay provision. So those are the LS 608.1 and 608.2. Again, no need to remember that, but if you do want to bring it up online, if you were to Google that, would bring up the form for you. They're also readily available on the DOL website, the FAIR web page. We also have here an 800 number and an email address for labor standards. You're more than welcome to take down that information. So it's 1-888-52-LABOR or lsask@labor.ny.gov. So we do have a question. Do you recommend a particular sexual harassment training program or coordinator for employers? So the Department of Labor, in conjunction with the Division of Human Rights, they have made trainings available for employers to utilize. Just, So I don't necessarily recommend that versus another agency. I'm not really well versed in, other agency programs or coordinators that are out there to be able to recommend. But what I can tell you is that, like I said, there are trainings, sexual harassment prevention trainings that are readily available for public use for the employers um, here in New York State that you can pull up online. And I guess the benefit to using something like that would be, that the employer is covering all the bases that are necessary because it's been provided by New York State. So it's going to be in compliance as far as the training goes and the documents, templates that are provided that are available there. Employers can kind of just fill them in with their information to make it relevant to the company. So that is one option that employers have. Thank you for that question. So on that note, we're almost at the end here, but so if anyone does have any other questions, please feel free to type them in. But I do just want to give some attention to the topic of retaliation. A lot of times workers are hesitant to make complaints to the Department of Labor because they fear that their employer is going to retaliate against them in some way, which, unfortunately is something that happens. It happens a lot, but also it's good to know that New York State does have very strong retaliation protections in place. So retaliation would be any unfavorable action against an employee for complaining about labor law violations. So under New York state law, it is illegal for employers to discharge, penalize, or in any manner discriminate or retaliate against an employee for making a complaint about a possible labor law violation to the employer or to us at the Department of Labor, or for cooperating with labor standards investigation. So again, if you think you've been retaliated against for asserting your rights under New York state labor law, you can go ahead and contact labor standards about that, and they can assist. So, retaliation itself, it can look like a lot of different things. It might be simply flat out firing someone for complaining, but it could also be, maybe reassigning someone to a less desirable job or a less desirable shift, cutting their hours, giving them a demotion. So labor standards investigates those things. If they do find that retaliation occurred as a result of someone exercising their rights under the labor law, they can issue penalties to the employer. They can also, pursue lost wages on behalf of the employee and any other appropriate relief for that situation. So I'm going to check the Q&A. I see one more thing popped up, but we have arrived at the end of the presentation, and I want to thank everybody for joining and listening today, and I hope that you learned something new. I do have a short post-event survey that you can access through the link or the QR code on the screen. I would appreciate it if you would take a moment to give me some feedback. Thank you all so much, and thank you to Sal and the Miller Business Center for having me this morning. I appreciate it.
Thank you so much. This was so informative, and there was such great information here. And I thank everybody who attended, and thank you so much, Stacey, for doing this for us.
Awesome. Thank you.